doing?
I'm in Hainan Island. You went there 2015.
Yes.
Yeah,
Right.
yeah.
A beautiful place. Hello, Frank. Hello, Henry.
Hi, Professor.
How are you tonight?
Good.
There's Tom. Hello, Tom.
Hi, Professor. I'm fine, thank you.
Good. Should we wait one more minute for people to sign in, or should I start? That was a question.
We can start. Yeah, I caught 68 persons attend. 69, 70.
Yeah, it keeps going up. Let's just wait 1 minute because the last two times people signed up. See, it continues to go up a little bit. We'll wait 1 minute, and then we will start. Hello, Tom. Good morning. Good morning to me. I keep saying, good morning to me is good evening to you.
Yeah. Good morning, Professor.
I have a cup of coffee. You should all have a glass of wine.
Yes. Maybe the wine can make me can benefit from me sleep.
Yeah, well, exactly. Or get a stiff drink. Okay, so I'm sorry.
Yeah.
Okay, so let me share my screen, and we will start. Okay, so this is the third of these advanced lectures, the challenge of electronic, AI, and machine evidence. Let me remind everybody of something I said about this. The first two lectures go to the very foundations of the field of evidence, not just legal evidence actually, but any kind of evidence, but obviously applicable to legal systems. And these basically are a very important part of my own research program. When I was asked to do these lectures, I was asked to also think about the important new challenges to legal systems. And there's one extremely important one, and that's what the third lecture is about, the challenge of electronic evidence, artificial intelligence, and machine evidence. But let me remind you of something I said the very first day. I don't purport to be an expert in this field. It's like any other area of the law of evidence that one needs to know in order to be an expert in the law of evidence, but I've never done any research or written about this myself. So this is a bit of an exploration for all of us in an interesting kind of way. So here we are. That's what we're going to do. And this is what I intend to do as we go through. And then hopefully you can tell me about things in China during our question and answer period. I want to do a little bit about the background. Machine evidence, what we call machine evidence, that's any kind of evidence produced by something other than a human being. Actually, it's been with us for a long time. Breathalyzers, medical tests, lots of experts. We say domesticated. We handle that in different ways, usually just through making an expert testify and allowing that person to be cross-examined. And that's how we would test the reliability of the evidence, which worked for things like breathalyzers and medical examinations and so on. There was this, in terms of our relationship, the legal system's relationship to electronic evidence, there was a big turning point, a big event that occurred with computerization. What happened with computerization, especially as that era progressed, was it became extremely cheap to store information. And today it's, I don't have a thumb drive right in front of me, but today on a thumb drive, on a good thumb drive like that, you can basically store the Library of Congress. The Library of Congress in the United States has a copy of every book published in the United States. And you can basically store the whole thing on a thumb drive. It was very, very cheap. But the problem is it's not cheap to investigate it, to explore it. If you have to dig out information relevant to a lawsuit from all kinds of emails, that can be really expensive. And this was the first trauma, the first problem with respect to electronic evidence that we faced. Then, in addition to just that problem, artificial intelligence, some machine learning is just a form of artificial intelligence. It's where you put inputs into a computer program, and the computer program processes that information and makes predictions about different kinds of things. This is what allows computers to act like humans, to talk to you in a really sensible way almost. Well, there were certain problems. If you had a computer algorithm that was being used at trial, like, for example, to make predictions about dangerousness in a criminal case, you needed to know how well that computer program worked. Well, as we'll talk about, it turns out that often is impossible, that the computer programs now are almost self-generating, and even the engineers who create them and the AI people who create them actually don't know, in some instances, how they work. That's why I say they are inscrutable in many instances. So we'll talk a little bit about that. And then what I wanted to do was talk about the legal standards in comparing the United States and Europe, and then having you talk about that with respect to China. That turned out to be interesting in that there aren't very many legal standards yet. We are still struggling with this. So what I am going to do is I'm going to walk through the challenges of artificial intelligence, learning, deep learning, and so on, from the point of view of a criminal defendant. To prepare these lectures, actually, this lecture, I consulted the top two experts in the field in the United States, Andrea Roth and Rebecca Wexler, and I'll show you them in a bit. They are at the forefront of our trying to grapple with these problems. Now, a few preliminary remarks. With respect to electronic evidence, these problems may be very domain specific. And what I mean by that is the problems we have in the United States may not be the problems you have in China. In our system, in civil cases, not criminal, but in civil cases, when I say we have free discovery, what I mean by that, I don't mean it's not costly, it can be costly, but you have to turn everything over to the other side. It's called discovery, open discovery. And whoever produces that information has to bear the cost of that. You know, whether this is a good system or a bad system is for others to judge, but that's our system. In a system without discovery, you may not have the problems we do. And this is an example of what I was just talking about. Suppose you were a big corporation being sued, and you wanted the emails. Somebody wanted the emails that are pertinent to the litigation. Like, by the way, I don't know if you're paying attention to Twitter. I don't even know, maybe your government blocks Twitter. I don't know. They do a lot of other crazy things. But Twitter is now exposing the emails concerning Twitter's suppression of the story about Hunter Biden's laptop. Well, okay, suppose there'd been a lawsuit and Twitter had to go find all these. Well, here's just an interesting statistic. There are 3 billion emails a day, not in any particular company, but across the world, across the country. A big corporation like IBM or whatever will have billions and billions and billions, if not trillions, of emails and electronic bits of information. And that's the problem when you start searching for them. You can't just click a button and get everything that you want. And so what happened was our system of free discovery became a problem, because a company could be bankrupted, could be driven out of existence because of the costs of having to turn all this information over. Now, here, interestingly, artificial intelligence I would say, is starting to come a little bit to the rescue, in that now what, of course, the AI people are doing is developing automated methods of searching. You do that when you use an electronic database searching for legal issues, or whatever you do when you search, the internet. Now that's going in the right direction, but still at some point you have to have eyes, a human eye, look at the problems, because of the complexity of language. You can't always predict whether something will be picked up by a word search, or whether what is picked up by a word search actually would result in turning over the wrong information. As a result of all this, the first legal point I want to make is this all led to changes in the federal rules of civil procedure. Now, again, all under our law, and this is true of the states too, and remember, every state is sovereign in a sense in our country. They all have their own systems. So I'm going to be talking about the federal system. there's a federal courts that cover the entire country, and then each state has its own. But this is true in all the states. Open discovery, you have to turn over everything. It's not privileged. That, by the way, is one of the reasons a human has to look at the material. You may pick up stuff with a word search, pick up material with a word search, but it turns out it's privileged. It's lawyer-client communication. It's very hard to program a word search mechanism to make that distinction. Then what you do is you list things that are privileged, and then the court can decide whether you're right or whether you're wrong. And all of this is designed to be cooperative, and there are various enforcement mechanisms and the like. Well, as I say, the problems are obvious. Number one, the expense. And if you just turn everything over to the other side, well, once it's disclosed, the adversary knows it, and it might in fact be privileged information. So this is you can read these things later. This is what we did in order to try to simplify this, and this is the first major response to artificial intelligence and electronic evidence. So we changed our rules about privilege. It used to be that if you turn something over that was privileged, like you turn a client privilege, work product doctrine, marital privilege, medical privileges, you waived the privilege. That is what made these searches so costly. A human had to look at every single email, or every single tweet, or every single text message. Well, now if you have reasonable mechanisms in place, and you turn something over, and you later on discover it's privileged, you can then claim that, and usually the court will conclude it's privileged, and that can't be used. But of course, still, that's been disclosed to the adversary. They can't use it at trial, but they know it, and it could be very important strategically. Now, so that's one interesting effect of electronic evidence. But again, this may be domain specific. It may be a problem for us, but not for you, because of your different approaches to discovery. Now, note, I'm also only talking here about civil cases. Why? Because there is almost no discovery in criminal cases in the United States. There's a little bit here and there, but almost none. There's nothing like the civil arena. So this problem has not been a problem in criminal cases so much. What we call white collar crime, when the government is bringing a criminal action against a corporation, well, then you could have these kinds of problems, but those are relatively rare. There's another problem, and having to do with social media, Facebook, Twitter, TikTok. What are the limits? What are the limits under our Constitution that protects rights to privacy, the right to be free from compelled self-incrimination, unreasonable searches and seizures? Are there limits in what the government can do now? I'm thinking just about the government of securing this information. I'm not going to talk about that. I'm going to talk about the technical details, if you will, of artificial intelligence and machine-driven evidence and so on. But this is a big problem. Like, you completely lose your right to privacy when you put something on Twitter or Facebook. Can the government go get information like cell phone information, cell phone location when you walk around with your cell phone, it pings, it gets into contact with cell phone towers, cell site towers. That information is known by the corporation that who provides you your cell phone service. And if the government asks for information, they physically can provide it. And the issue we're having in the United States is, when does the government have to get a warrant, even though they're getting information from a private person? A lot of interesting questions here. Or with respect to a computer, can the government make you turn over the password to a computer? Or if it's a face recognition phone, can they make you look at it so they can open it up and look at what's inside? A lot of really, really interesting questions. And that's why I say Fifth Amendment questions, Fourth Amendment questions, privacy questions. Now, one of the things I found interesting when I began preparing this talk is how ill-developed this entire field is. It would not have been possible for me to do a presentation like the last two lectures have been, because this is all new. It's all just coming down the road, coming down the pike. Everything is in a state of flux. So what I'm going to do is I can walk through all the issues from the perspective of a defendant facing artificial intelligence, machine evidence, from the United States perspective. Now, again, this may be domain specific, but going through this in this way will show you the problems, the issues, however they are resolved. Here are some references for you. This is the early literature on this topic. There's others, but these I found particularly helpful. And as I mentioned, these two people, I consulted them, Andrea Roth and Rebecca Wexler. They are professors at the University of California, Berkeley. Turns out they're both the same place. And I consulted them in preparing this talk, and they are two of the leading experts in the United States. So here are some materials for you if you're interested. So what are we going to be talking about? Algorithmic decision-making by computer-like machines. You could take the "like" out there. These are computers. When you do a DNA analysis, you now have machines that you put the blood in. You put it analyzes it and gives you a DNA phenotype. Well, has it done the job or has it not done the job? But it's a computer. It's a computer attached to some chemical tests, but it's a computer. All these things really are computers. They're computing information. And with respect to all of them, these are the problems. Is it reliable? I mean, how do you know the black box is working? And is what it is doing transparent? What does that mean? Can you tell what it is doing? And as we'll see, in some cases with machine learning, as I mentioned a second ago, it essentially writes its own program, and the engineers who created it don't really know what it's doing. It's really quite remarkable. More and more of these things begin to look like a human mind. But in any event, if you're a criminal defendant and the government has produced information from a machine, you want to know, is it reliable, and how do we know it's reliable? So what machine learning really is it's just learning by example. So we start with a simple algorithm, and then we feed information into the machine, and we say, this is right, this is wrong, that's wrong. And the machine then starts to accumulate knowledge, actually, about this subject matter area, and then creates its own criteria for judging whatever the issue is. So here are the problems in this area. And here's again, I'm going to give you lots of references today for you to consult at your leisure if you're interested in this field, and you should be interested in this field. This is one of the really important developments in the law of evidence. So, are collection mechanisms reliable? What about tampering, cyber attacks? The government says they have emails of mine. Well, it turns out maybe somebody forged those emails. Who has access to this information? Who could we say adulterate it, change it? what mistakes are made, what can go wrong, how is data transferred. Now, every time data is transferred in an electronic format, it's changed. It's a really interesting point. You don't have original documents like you do of a contract, a physical entity. You have files. When you copy that file, it's not the same file. It changes. Now, usually doesn't change in a significant way, but the idea of talking about originals doesn't quite map on to the reality of this electronic world. And of course, things can deteriorate. How you've all experienced turning on your computer or your phone, and it doesn't work. Something went wrong, you have to reprogram it, or even just reboot it. Sometimes rebooting it will correct the problem. But that's an example of a deterioration in the program. And of course, this is the biggest problem of all, the reliability of the underlying technology. So that problem is made worse, we say exacerbated, made worse in the United States because of our intellectual property laws. So industry out there is creating these different techniques. Like here are just a bunch of examples, and Rebecca Wexler, remember, that's one of the two leading experts. A very interesting article here for you. So you have all these things, that are going on. Hotspot neighborhoods. That's a computer prediction as to where crime is going to occur. You can flag individuals at risk through social media, software programs to analyze. All this stuff goes on. And now you're a criminal defendant and some evidence is being presented against you. You want to test whether it's reliable or not, right? Of course you do. Well, the only way to do that is if you have access to the underlying computer code. That's not quite true. It's not the only way, but it's a very effective way is to have access to the underlying computer code, and then you can have your own engineers test it and so on. But that underlying computer code is usually protected intellectual property. So now we have a conflict between our desires for accurate outcomes in criminal cases on the one hand, and the intellectual property laws on the other, which protect these computer programs, and they can be extremely valuable. So here's a really interesting, again, reference for you on machine learning. And as I said before, even if you have access to the original code, that can be, as information is fed into the machine, and the machine actually decides, what it thinks is right and what it thinks is wrong. That actually results in a change. So even if you had access to the underlying code, that doesn't tell you what's going on now. And as I said a couple of times, even the people who create these computer programs don't really always know what is happening. Now, think about it again from the point of view of a criminal defendant. How do you test that? It's a really interesting problem, actually. So here is, I'm going to run through this problem from the point of view of what a person at trial would face. And here I'm relying very heavily on Andrea Roth. And again, these two people, Andrea Roth, Rebecca Wexler, are the people whose work you should read to start if you're interested in this. And she's a friend of mine as well. That's Andrea, sitting on the sign at the Berkeley Law School. Okay, so what's machine information? Well, we've talked about that. It's something that comes from a machine that's being offered in a criminal case as evidence against a defendant. Just a picture of a DNA analyzer. When does it come up? Well, it comes up all kinds of different places. Risk prediction, bail, sentencing, post-conviction, investigations, the hotspot point that I just talked about, what we call the shot spotter. Now police departments are using this form of machine evidence to hear what they think are shots being fired and gunshots. And when they do that, then they rush to the scene, and it turns out sometimes it can be very effective. It can be used as proof of guilt or innocence at trial, like what? DNA, fingerprint analysis done by computers, DNA, blood alcohol levels, probabilistic genotype software. These are just examples of things that are done. And this is, you know about DNA and so on and so forth. These are the kinds of results you get. Now, if you're a criminal defendant, you want to be able to test these things, right? More examples of machine evidence is becoming, we say, ubiquitous. It's everywhere. Do you have red light cameras in China? Red light cameras are cameras at intersections that record the cars going through the intersection and whether or not the light is green or red. And if it's red, when you go through it in the United States today, you'll get a ticket, a traffic ticket. You come to your house and you have to pay, the ticket will come to your house and you have to pay $100 or whatever because you ran a red light. We also now have speed cameras that do the same thing. They track the speed of cars, they take a photo of the license plate, and then you end up getting another ticket. All done mechanically with machine intelligence. Fitbit data. There's a series of interesting cases in the United States. Let me tell you about one. A person claimed that a family member was killed, the wife was killed. And the person claimed that it was an accident. He had a heart condition and he wore a Fitbit as one of these watch-like things on your wrist that keeps track of lots of different things, but including physical phenomena. The government was able to tell from his heart rate and respiration rate that the story of an accident that he was saying happened could not possibly have happened. This Fitbit data that he was wearing, in essence, convicted him of a murder. It's really, really interesting. Think about Alexa, the microphones that are in people's rooms and houses now, attached to Google or whatever, Microsoft. They can be listening all the time. And in fact, Google and Microsoft say you can turn them off. Well, you really can't. And so now you get a lot of this information can be stored. You see the point. AI-based medical expertise, same thing. This is just an example of a lie detector test that's now being developed. Legal informatics, right? You go searching for information, and that's a machine intelligence, machine evidence-driven sort of thing. Now, how should you deal? How should the criminal system deal with a machine? How do you know when it's fair? How do you test it? Well, why not just apply the rules, right? Whatever rules. So here are the rules. Here are the problems with witness testimony. Insincerity, ambiguity, misperception, memory loss. These are the things you test a witness for when they testify at trial. And how do you try to increase the probability of them telling the truth? Well, through an oath, right? You're sworn to tell the truth. You physically confront them, our confrontation clause, and you cross-examine. None of that works. So here, step back from this. We have this traditional set of mechanisms for conducting trials. You know, how well they work, people can disagree. There's some ways in which it works well, some ways in which maybe it could be improved, but we have them. Now in comes this alien force that's really important and providing direct evidence of guilt. And it can't be domesticated in the same way. It can't be treated in the same way. This is the central problem. So how do we do it? Well, Dalbert and Fry. This is scientific evidence, and you all know about scientific evidence. So one thing you do is you try to treat as scientific evidence. But look, when you have a machine that's simply functioning, there's no human expert presenting that, and there's nobody to cross-examine. Something about the confrontation clause, well, there's no concept now of confronting a machine. Yeah, just raw data. Authentication requirements, this is, as you probably know, there's one and only one universal law of evidence. And this is literally true, at least in our country. I mean, you may have others, but there's one and only one universal law. It's never written down, but it's the one universal law. Everything has to be shown to be what it purports to be. Whatever, when I offer evidence at trial, I purport it to be something, which means I assert it is something. It's the contract in the case, it's the eyewitness testimony, it's the blood analysis from the person's veins. I have the obligation to show that what I say it actually is. And I have to do that through the presentation of evidence. And there's some mechanisms to deal with that. That, at least as an analogy, can be done in this area. You can try to require the proponent of whatever the issue is to show that it is what they say it is. But that's the only tools we have right now. Now, is that good enough? No, it's not. These are just examples of how complex DNA, for example, DNA analysis can be. And these specialists come in, and this machine has produced this DNA analysis. They don't actually know that it's worked properly. You don't know that it's worked properly, and you can't ask the machine. So what do? Well, you can't let the the advocates cross-examine the machine. Well, the programmer, yes, you can do that. But note how you're getting farther and farther away from the core issues of trial. Note how expensive this is going to be. The inputter, you can cross-examine the inputter. I mean, a good example of this is, you probably don't remember the O.J. Simpson case anymore, but one of the claims in the O.J. Simpson case was that the police actually planted his blood at the scene. That's like the inputter, and you can examine the inputter and ask, did you do things the way they're supposed to be done? Whoever operates the machine, you can operate it. You can bring the operator in, and again, you can ask, did you plug it in properly? Did you push the right buttons? Did you do this? Did you do that? Did you do that? And sometimes you can find problems, but again, even if you don't find problems here, it still doesn't mean that the machine does what you think it does, or you get reliable results. These are just examples of where this problem came up in the United States, Bull Cumming versus New Mexico. So again, how do we safeguard, defend against the machine testimony if you're a criminal defendant? So here's a list of things, again, from the perspective of an American criminal trial. There are pre-trial safeguards one can engage in, so you can try to test the software. This is a not-for-profit group that does provide standards for testing software. So you can do that. You can require disclosure of information about a machine and machine learning. When I say machine, I mean machine learning, artificial intelligence, any of the above. You can make the machine available, and this is now one of the things that's occurring. You start to treat the machine. When I say machine, again, computer program, breathalyzer, whatever, and let the other side test it. You can do that. You can get independent licensees to try to test it. And here's the big ticket problem. You can try to get access to the source code. Why does that matter? Because if you have access to the source code, you can have engineers, computer scientists, possibly decipher it, understand it. So what about at trial? So these are pre-trial things that one can do. what a trial. Well, I want to hear from you about you. We need to rethink our expert witness rules and try to figure out ways to apply them to expert systems. Expert systems are these examples of machine learning and artificial intelligence and so on. By the way, none of this is being done explicitly. There are cases that are starting to do this. Remember, I said this is a developing area. You could require certain testing formats or criteria before you let in anything driven by a software package. We could do that. We have to think about that. We could require source code disclosure. We haven't done this yet. Inching in that direction because the courts are beginning to perceive that if the criminal defendants, and remember I'm talking about criminal cases because this is where it's most stark, if they don't have access to the code, they really can't confront the witnesses against them. They can't confront the evidence against them. You can run tests, you can require more than one run on data, and then you can instruct the jury. And these are things you can do to try to start to deal with these problems in a criminal trial. So sort of summarized, you should ask for discovery if you're in our situation. You can investigate, you can tinker with the machine outputs and consult people and do this and do that. You can try to use Daubert and the scientific evidence requirements to exclude evidence. If the other side really can't show it is what it purports to be, or really can't show that this is science, reliable science, well, then you have a possibility of getting it excluded. How do you impeach? How do you impeach a machine? By cross-examining the humans that are involved with it. And then you can make arguments to the jury and ask for jury instructions. Here are the things a criminal defendant, or actually a civil defendant too, a civil plaintiff, needs to know. You need to know what the program is, how it's designed, how it's tested, how it processes information. That's the machine learning. Point number 4 is the machine learning aspect of this. What problems have come up in the engineering and creation? Things are presented to the market, new devices, new objects, new this is new that, are presented to the market as though, well, they're perfect. Well, of course, they're not perfect. And we often learn later on that indeed the manufacturer, the designer, the creator of whatever it is, a new car or whatever, had all kinds of problems, but of course they don't disclose. So one of the things you want to ask about or try to find out about is those problems. We've talked about this, to ask for the source code. Jenks of the machine, this is a reference to American law. The prosecution under American law, and also this is Brady versus Maryland, the prosecution under American law has to turn over any evidence that could exculpate means suggests that a person isn't guilty. Sometimes you have to ask for that information. And so one of the things our criminal defense lawyers would do is to ask for it. And what you should do, and if you ever deal with this in your own lives, is the same thing. Ask for things, what's going on here. Of course, this is the problem you're going to get. Someone will say it's a trade secret, or it's a patent and intellectual property. They wouldn't say a patent, because actually, if you patent something, you have to disclose the information in a patent system. So to patent software, you actually have to disclose the software. That's why a lot of software developers don't patent their material. What they do is they claim it's a trade secret. That it's like, I don't know if you know about Pepsi and Coca-Cola. They have secret recipes that no one knows. If they're hidden in vaults in the 2 different companies, and 1 or 2 people have access to the actual recipe. And they've been sued a number of times, and they've simply refused to ever turn this over. It's not, if they patented it, they would have to turn it over. So they say, no, we're not going to patent it. We're going to keep it as a trade secret. What else can we do? Well, you can claim that this process of using this evidence against you looks like a confrontation clause problem. In our system, you have the right to confront witnesses against you. We have to translate that, figure out what that means with respect to artificial and intelligence and so on. Now, these challenges are happening, but they're just developing. We don't know where it's going to go, and you see some problems, and that's what this slide points out. Does something like our confrontation clause, it says you have right to confront the witnesses against you, does that even apply here? Is the term witness, does it mean human witness? Well, I'm sure whoever wrote the confrontation clause thought that because they didn't have machines, but now are we going to extend that to machines? And are we going to think about things in terms of confronting the machine? What does it mean for what a machine produces to be testimonial? That's a big ticket item, because if it's testimonial, you have to be able to cross-examine the thing or person giving testimony. These are all the interesting problems that are emerging in our system. And here is another couple of references for you about this if you want to pursue this, further. What other strategies can a defendant employ? Well, Dalbert, Frye, reliability-based challenges we've already talked about. But here is a collection of the ways to think about this. And what does it mean for there to be scientific validity? What standard does the government, always is the one presenting this information, have to meet to produce it? Well, at least this, presumably, you have to have reasons to believe from testing that the software accurately produces what it claims to produce. What if there isn't industry-wide standards? Does that matter? It probably should, because industry-wide standards start to give you some basis for thinking it's reliable. Has there been sufficient validation of the output that shows the accuracy? How about internal validation? That is, checking the software. Has this occurred? These are all challenges that can be made by a criminal defendant. This is what the IEE is, the Institute of Electrical and Electronics Engineers. They're putting out standards. And so that leads into, again, thinking about this from the point of view of scientific evidence. You all know, or probably know, about the Frye test and general acceptance. Is there general acceptance of things? What if there's a lack of sufficient developmental validation? Has it been independently tested? Has it been independently tested in a context of a valid context? Is it testing something that looks like it would be a test of the whatever the test is or whatever the thing is in the real world? What's called ecological validity. Is it ecologically sound? Are you doing what you have to do? And last, what's actually being tested? Are you doing the right thing? Again, all challenges that can be brought to this stuff. Standard validity questions. How often, this goes back to what I was talking about before, find out what the problems were in development. How often does it come to the wrong result? These are just pictures that are interesting. Now, validation's a problem. If it's validating just a simple thing like is alcohol in blood, that's one thing. But sometimes you get what are called likelihood ratios. That's, for example, in some DNA testing. It's a subtle point here, but to validate something, it has to have a discrete score. It has to have a true variable, a true outcome. Some of these are not. Some of them are, when you're dealing with things like likelihood ratios, there isn't a true measure of whether it's true or false. You have to find out if that's the case with whatever it is you're dealing with. Here again, throughout this entire process, I'm giving you these references so that you can go further with them. You can do this, of course. You can cross-check most of these things that we're talking about, like blood analysis, red light cameras, shot spotters, hotspot determinations. There are competitors on the market, so you can go and look at a competitor and compare results and do things like that. But again, here's just a reference if you want to look at it. What if there's a lack of sufficient internal validation? When you do internal validation, somebody is determining what it is you're validating, and you have to know what that is. And different producers can do different things. You need to know what it is and try to find out what it is. This is, again, an example that you can go and check for yourself. The next thing you can do at trial is you can put software results in context. How do you do that? Well, you examine the expert, whoever the expert is, whether it's the developer or the engineer or whatever. Here are some questions that you can ask. In a cross-examination of either a software developer, a computer engineer, an AI person. Have you done all these things? So on and so forth. I can't give an algorithm, a formula for cross-examination, because in fact, it's going to be dependent on what the particular issue is that you're dealing with. And then, of course, you can ask for a different computer, which means let's try this in a different way. And then in our system, kind of last, is you can ask for jury instructions, and you can argue to the jury. You can make whatever argument you like to the jury. And here are some examples of jury instructions. Now, this does not map onto your system. And remember, what I said at the very beginning tonight is that some of this is going to be domain, and maybe a lot of it is going to be domain specific. But these questions that we would ask a judge to instruct a jury on are also questions that go to the validity of whatever it is you're dealing with. So these are just suggestions about ways to cast doubts on the credibility of some product from machine intelligence or artificial intelligence. The absence of answering these questions effectively could lead to reasonable doubt. If the software engineers, the AI people, the machine learning people can't answer these questions effectively, it's like, not spoliation of evidence, but it's almost like it. There are missing gaps, and missing gaps can then become the basis of reasonable doubt. Here is just an example of a closing argument made in a DNA case, emphasizing to the fact finder. Again, you have fact finders. You may not have jurors, but you have fact finders, emphasizing again the way in which they should think about what has been presented to them at trial. Now, that's how these are all the problems in the United States. So what I was hoping to do was make a comparison between what happens in the United States and what happens in Europe, and then hear from you about China. As I told you, in the United States, this is all new. So I really couldn't put together a systematic presentation. I could give you a whole set of ideas like we've talked about. So then I thought, well, it'd be interesting to compare this to Europe. So I went to the leading expert in Europe about these issues, and it's Giulio Lasagna at Milan. And guess what? It turns out Europe has made probably even less strides than we have in the United States, probably because Europe, and of course I'm lumping all different kinds of countries together into one. but has less of a commitment to the adversarial process. One of the advantages, maybe sometimes a disadvantage, but one of the advantages of the adversarial process is it forces the production of evidence. They don't have that, and whether that's the explanatory variable or not, it turns out there isn't much that you can say systematically about these issues in Europe. But I'll give you a few points, and make of them what you will, and I'll give you some resources to look at. Here's kind of a starting point. Let me back up. No, there's no agreement in Europe about how digital evidence should be handled differently. There are different standards that are developing, and I'll refer to some in just a second, but no, the European systems don't have the same sharp distinction between admissibility and sufficiency that we do. And that might be good, that might be bad, but they don't. So they don't talk so much about admissibility. That then makes it opaque, unclear what role any particular evidence has in a criminal case. And clearly that within Europe, when you look at these different countries, there's no harmonization, there's no clear paradigm that's evolving. When you look at the European Union, it looks like these are the questions that they're facing. What are the legal bases that support the establishment of transnational admissibility rules? How can they provide European-wide standards? Should they be specific to digital evidence, and should they be shaped? Now look at this. These are all preliminary questions. This is kind of where Europe is now. They're just, well, kind of like the United States. They're just thinking through these problems. And these things all are all relevant to the central problems of machine learning, artificial intelligence that I've just already discussed in the context of American criminal trial. They just use different terms. Is the data, has integrity been satisfied? Has it been adulterated in any way? Can you verify it? And is it complete for, in the sense that there's nothing being left out of the picture? These map onto exactly the questions of cross-examination that I was referring to earlier. There are standards, and here's again, those of you who want to pursue this further, the International Organization for Standardization and International Electrotechnical Commission has proposed various standards for digital evidence, artificial intelligence. No one has adopted them. It's interesting, they may, but no one's adopted them. The Council of Europe has set a couple of guidelines. Again, here you can go check them out if you're if you like. They're not very enlightening. Basically, the sort of the exhortations that one often gets from Europe to be concerned about justice and dignity and this and that, it doesn't tell you very much at all. Here are those guidelines that the European Union has formed. As I say, if you want to go look at this further. It turns out that there are some conventions. The Budapest Convention is one, but look at what it says. It's just an exhortation. It demands that investigative measures be carefully drafted. Well, okay, fine, great. It notices that digital evidence, like anything else, can be misleading, and you have to be careful about it. But as I say, almost no developments in the law of evidence in Europe. The European Court has done a few things, but here is what one scholar, how they summarized it. When you look at the activity of the court, they focus, the European Court of Human Rights and the Court of Justice have focused on privacy and the capacity of these electronic systems of different kinds to violate a person's privacy. but they haven't taken the next step and gone to admissibility. The Court of Justice has done a little bit more. You have to exchange information about whatever it is you're dealing with, but not very much. I mean, again, interesting. We're all struggling with the same problem. You probably know about the EU's General Data Protection Regulation. This has come up not in the context of trials. This has come up in the context of limiting what Google, these big tech companies, Google, Microsoft, Apple, can do with information. And it requires, as I point out here, it requires that they disclose how their programs are making decisions. We don't know how this is going to work out. We'll find out. You do see fines being imposed because of the failure to comply with some of these requirements. But go back to where one of the most important points we talked about tonight. In many instances, you can't tell how the algorithm deals with the particular data because the algorithm has evolved. And so it's going to be really interesting to see how this all works out in the real world. And here again, I think my main objective tonight was to give you sources to pursue this further to the extent you want to. And here was a source that I found that was interesting, that discussed the implications of all this stuff that we're talking about in Europe. And so kind of there you are. Okay, so it's late on a Saturday night. I'm going to stop now. Thank you for listening. And I look forward to hearing how these issues are handled in China. I hope I provided some things for you to think about. It was very interesting to me to do this this project because, as I said, it's not something where I would claim to be the world's leading expert. Some areas I am, but not in this. So I hope you find this interesting. So let's have a talk for however long you'd like. And so whoever wants to start. Nina Chong.
Hi, Professor Allen.
Hi, Nina, how are you?
I'm good. Nice to meet you online.
Nice to see you on a Saturday night.
Yeah, maybe we met 3 years ago in Shenzhen. Do you remember?
Yes, I do remember.
Yeah, thanks. So I'm really interested in your lecture tonight. And I have one question. Just you said, due to the COVID and the online litigation, is really popular in China now. I think maybe also popular in USA.
Yes.
Yeah, so there is so many electronic evidence or maybe the electronic materials in the court.
Right.
Yeah, so just you said, the electronic evidence dominates the court now. Yeah, so maybe I think it's a lot easy for the layperson, the judge, it's a lot easy for the layperson to define, what is the original, what is a copy,
Right.
Yeah, so maybe I think there's many challenges to the traditional base evidence principle. Yeah, so maybe I think there is a new concept for the traditional base evidence principle. Yeah, so how do you think? What is the new concept for the traditional base evidence principle? What is the best evidence principle?
Right. So for those of you who are not fluent in American evidence law, we have a rule of evidence called the best evidence rule. It doesn't mean the best evidence of things in general has to be produced. As Nina points out, what it means is the original of something has to be produced. So if you have a document, you have to produce the original. You're litigating a contract. You have to show up in court with the contract, not a copy of it. This arose in the 17th, 18th centuries because of fear of forgeries. Now, as she points out, and that's very much related to things we're talking about tonight, it's not even clear what the original is in software. It's not clear what the original is in anything digitally stored.
Yeah.
Every time you think, well, no, wait a minute. Yeah, you've got a file and you copy it. That file is the original. Every time you copy a file, I'm told by the computer engineers, I'm not a computer scientist, but I'm told by the computer engineers, every time you copy a file, it changes. And maybe, Nina, this is what you're getting at. It changes. The copying process itself affects the digital code. So this is a very intelligent question. What does it even mean now for something to be an original? I think what we will see, but this is just my guess. My guess is the system, the legal system, will look for ways to try to ensure reliability in copying, in transmitting, in inputting, and so on. What those forms of reliability will be is going to depend on software engineers, right? It's going to depend on the science itself to come up with ways. So there are now ways in which I'm told, again, remember, I'm not an artificial intelligence specialist. There are ways in which you can now determine how often a file has been consulted, how often it's been looked at. Have there been any changes to it? Sort of like what's called the metadata. Do you all know what metadata in a document is? When you're typing on your word processor, and almost all word processing systems, it keeps track of actually what you're doing. How often you consult that document, call it up on your screen, what changes you make. That's called the metadata. And that metadata can be really important in some litigation. For example, using Nina's examples, in many cases, somebody will show up in court with what they say is the document, and then you look at the metadata and you see it's been changed. People have adulterated it. So we're going to have to come up with schemes that look like that, right? Look like ways in which you can keep track of what occurs to a file and so on. But so it's an extremely good question. I'm not giving you a very good answer, right? What I'm saying is we have to come up with ways to deal with it. And that's exactly right. And we don't have them yet. But related to your point, do you all know what deep fakes are? Have you ever heard of deep fakes?
Yeah, deep fakes, yeah.
Yeah, deep fakes are fake videos, fake digital storage. You can create a dinner between, it looks like Barack Obama, a very liberal president, and Trump, a very conservative. You can create what looks like them having a dinner together, talking about overthrowing the government of the United States, and it's going to be looks really, really true. And it's complete fake. This is a big problem, right? And this is, as I say, we don't have solutions to these problems yet, and at least not that I'm aware of. So, Nina, nice to see you again. Very good question. I wish we had better answers. We're into a new world.
Yeah, it's really interesting. I got it. Yes, thank you so much.
Zoe Cheng, I think you're next.
Hello, Professor. Can you see me?
I can see you and hear you. Yes.
Hello, Professor. It's really nice to see you again. And
Hi,
my
Zoe.
question is, hello. As you mentioned in class, the problem of machine trial is that we cannot exhaust all the evidence. In addition, I have observed that there also has a potential problem of machine trial is that the artificial intelligence has the algorithm bias or the discrimination because the
That's right.
algorithm, yes, because itself is designed by people and the people has their own culture or something, have their bias of designers. So I think the machine trial should be the natural, but the existence of this situation makes the judge's black box more confused. It would be wonderful if you could provide some comments on this matter. That would be great.
Well, Zoe, the only comment I can make is that you are absolutely right. That the person who writes the software may himself or herself have biases, explicit or implicit. The software may contain those. In addition, the way in which the early cases of machine learning occur will control what the machine thinks it's learning. And that could end up in creating an output that is itself biased, not because of the software, but because of the happenstance, the circumstances in which the first cases that the machine was processing, the computer program was processing, were presented to it. So you can end up thinking that some racial minority or racial classification, commits all kind of this. Somebody from a certain racial classification commits this crime because that's what the machine got at the beginning, right? And thus, what appears to be a rational output isn't. It's biased. And like the first question, I'm just going to say you're right about this. You're absolutely right. That's why we have to come up with ways where we can do what's called external validity testing. Test whether or not this machine, this algorithm, this artificial intelligence is actually producing what it says to be, what it says it's producing. And right now, the most important message here tonight is we're struggling with that. So yeah, that's my comment. You're just absolutely right.
So you think that would be struggle in the future, or just some days the intelligence would be better to fix this problem? Do you think that would be?
Yeah. So we're in a really early stage of this development. If I had to guess, given the creativity of scientists, I think, yes, we'll come up with solutions, may be too strong of a term. We'll come up with ways to reduce the negative effects of the things we're talking about. I don't think it'll be perfect, but human testimony isn't perfect either, right? So the issue isn't perfection. The issue is whether it's good enough. And these problems are known and they're being worked on, and maybe, just wait and see what happens. Now, again, in our system, I'm curious to hear about yours. In our system, one of the advantages of our system is this is driven by the adversary system. So, we have defense lawyers in particular in criminal cases, or even in civil cases, lawyers on both sides that are defending their clients' interests, and this drives the creation of new information. So in your case, you don't have as robust an adversarial system as we do, and so I just don't know what'll happen in China. But in our system, the lawyers will keep pressing and keep pressing and keep pressing, and I think that will have a positive effect. But that's just a prediction, and who knows if I'm right or wrong. Good question, Zoe. Thank you.
Thank you, Professor Allen.
Yeah, you're welcome. Bangda, nice to see you again. Or as soon as you turn on your video, I will see you. Hi, Bangda.
Hi, Professor. I ordered your lecture from the first day and until today, And in the first day, I feel I'm confused about the complexity theory. It is difficult for me to follow. And today's lecture, I think it is very interesting. And currently, I'm doing a small research about the artificial intelligence from the view of evidence law. And in my opinion, artificial intelligence is only a tool for human beings to facilitate their calculation. And the advantage of artificial is only, all we say is solely is calculation compared to human beings. So I think this field is difficult because we should look into do some survey about the practice. For example, in China, in various levels of the courts, we have applied this technology to improve the efficiency of the trial process. For example, in Shanghai, we have the one program called the 206 projects, and it is very famous in China. And also, I think artificial intelligence can use these techniques to calculate the probability of evidence. Just according to your lecture yesterday, I think probability, the theory, can be used or can be applied to calculate the relevancy of evidence, or we say the probative value of evidence. And so I have one question that is always puzzles me. 401 of the Federal Rules of Evidence, it goes like this. Any tendency to make a fact more or less probable than it would be without the evidence. So can we say probability measures the relevancy of the evidence, or we should say the probability can be measured the weight of the evidence? Which judgment do you agree? This is my first question. And
well, I'm sorry, go ahead. Yeah, go ahead. Go ahead.
And another question is, do you think the evidence generated by the artificial intelligence is an objective or a subjective evidence? From my point of view, I think it is subjective rather than objective. Because
well, let me.
Yes.
Oh, sorry. Go ahead.
Okay.
Go ahead.
Okay, that's all. Thank you, Professor.
Yeah. So to answer your second question first, yes, I think that's the problem, that we don't know whether what these machine learning devices and techniques are producing is subjective or objective. As we just talked about with respect to the first question, the software itself can be what a human would call biased, even though the software doesn't know that, because the software doesn't know anything, right? It's just a software that's being implemented. So that's exactly right. And until it's validated and tested and you have great confidence in it, then I think you have to think of it as subjective. As to your first question about the use of probability theory to define relevance, you're absolutely right. Rule 401 in our system, which says exactly what you said, that relevance is the effect of to increase or decrease the probability of some material proposition being true, some fact of consequence being true. But that's a heuristic. The more important point is that in fact you cannot know at the time whether any particular piece of evidence is going to increase or decrease the probability of a fact of consequence being true, because any piece of evidence, any offer of evidence, is contingent on all the other evidence. So all you can do is make what I call a localized decision. Well, what does that suggest? What that suggests is the real issue in 401 is not probability. The real issue is an offer of evidence pertinent to the explanation that the particular party is given. And that's exactly what goes on in Rule 401. You ask, is this offer of evidence pertinent to whatever explanation the party is offering? We reduce it to this probabilistic language, but when you think about trials as a whole, it can't be right. It can't be right, because what you think is evidence of guilt might turn out to be evidence of innocence, and you don't know that until you hear all the evidence. So as a heuristic, as a rule of thumb, as a way to proceed, sure, you can think of probability theory in that fashion, and that's fine. But realize at a deeper level, that's not what's occurring. What's occurring is the issue of allowing parties, again, in our system, adversarial system, to present the explanation that they want to prove explains the events in question. So nice to see you, Bangda. Tom?
Okay, thank you.
Hey, hi, Professor. Thank you much for your lectures. This topic, and as I think, is a really very fashionable and popular research topic at present. It can be said that is a universal topic rather than a local knowledge, like the guild said. And at present, there is a tendency in the research of evidence law in China. Once a new evidence form appears, the scholars are eager to find the kind of evidence to belong to, such as artificial intelligence evidence, electronic evidence, to distinguish from witness testimony and the real evidence. But I'm wondering, does this make sense? The first puzzle is whether this kind of evidence can be consistent or coherent in theory. As you demonstrated in a recent paper with one of your doctoral students, the law's aversion to naked statics and other mistakes, there is no need to hold an aversion to a type of evidence because it is new or different, but simply to increase scrutiny from the point of view of reliability. And the second puzzle is whether we should pay more attention to how this kind of evidence can be used in judicial proof. Yeah, thank you.
Yeah, no, Tom, I agree with everything that you just said. And I'm glad to hear that this is a popular topic in China. I look forward to learning from your scholars about this particular problem. We are struggling with it in the United States because on the one hand, if machine learning works, that's great, right? The best thing we could find is an algorithm, a formula, a machine that tells us the truth, right? Be very, very valuable. But the problem is, why would we believe it? Why would we believe it's telling us the truth? And we have to be able to test that proposition. We have to be able to test whether the output of different mechanisms and programs and operations is in fact accurate, providing us with the truth. That's the problem. So I would just say I'm glad to hear this is a big topic in your country, and I look forward to learning from you. And I agree that these are exactly what the problems are. I also agree, by the way, that we should think of this as not really different from any other kind of evidence. You want to do the exact same things. You want to test its reliability, its validity, its truth-telling capacity. That will be done in different ways, just like when you cross-examine a witness. You cross-examine them in different ways based on what their testimony is. It's not always the same. And I think, if I understand you right, I agree with you entirely. That's how we should think about this kind of evidence. But then we have to think about, how do we test it? What are the techniques? What are the mechanisms to ensure that it's providing reliable outcomes?
Yes, yes.
All right. Zhuan Yao, nice to see you again. You're muted.
Hi, Professor Allen. As a criminal criminal lawyers, attorney, and I envy your system as adversary system, and lawyers, as you said, can press at any state of the trial, and they have a lot of rights to assert. And firstly, I want to introduce some practice in our judicial practice in the criminal procedures. And right now, we have two major problems about the electronic data identification, or you can say authentication.
Right.
Many data check and the software function identification, especially when the cases are against the corporation crimes. The government as a prosecution will seek such institute to identify or authenticate that you're running apps, online apps, maybe have the function of fraud.
Right.
And they will came up a report or opinion of the expert in the institute, which they can run the business of data check, software function identification, just as CUPL, they have this kind of institute. They can do this kind of business. And months ago, I came across a case. It's against a corporation. They said the government said you are running apps committing fraud to others, and they have a identification that your app have function of fraud. So our lawyers, we don't have the power to confront the government.
Right.
So I envy your adversary systems. We don't have that. So all we can do is seek another institution to do another identification. Maybe came across, they turn out is the APP does not have that function of fraud. So we can say the corporation, that corporation is not guilty.
Right.
So, but the reality here is our judges always believe the government.
Right.
Their report matters, but not
Right.
ours. So it's not adversary systems like yours. So
Yes.
so that's full of problems. So as one criminal lawyer, I think we have so much to do to enact some rules or regulations to govern this kind of electronic evidence authentication or identification.
Right.
So we have so much to do like this.
Interesting.
Thank you, sir. That's what
Yeah,
I
so
can.
Go ahead.
That's what I can share with you the practice of China's systems.
Yeah. So there's a critical difference between your legal system and ours. In your legal system, the courts are obviously part of the government.
Yes.
And the iron triangle, the procurator, the courts, and the police, right? The iron triangle. In our system, the courts obviously are part of the government, but they are independent of the other branches of government. And at a criminal trial, it's not like the courts are there working with the government. The courts are neutral, and the government is just a party in front of the court, just like a person is a party in front of the courts. That's a huge difference between our systems. And we have the adversarial system has problems. I mean, don't let me say to the contrary, but it does have this benefit that the defense counsel can press on the kinds of questions we're talking about, and the courts will let them. And if the courts are convinced that the government is not telling the truth or whatever, they will decide for the defendant. So there is this critical difference between our two systems.
So I like yours system.
Yeah, well, as a defense counsel, I would too like ours. So thank you, Mr. Yu.
Thank you, sir. That's all I can say.
Sophia Lee.
Hi, Professor Allen. Nice to see you. Yeah, I just introduce a little bit. I come from Macau, China, and I actually worked as your translator 20 years ago when I was doing my PhD at CUPL.
Oh, wow. Well, nice to see you again.
Nice
that must have been my first
20 years. Yeah.
That must be my first trip to China if it was 20 years ago.
Yeah, I still remember the topic. You are talking about the jurisprudential and political foundation of criminal procedure.
I remember it too. Yeah, very well.
Yeah, it's nice to see you again. But I actually read quite a lot of your articles these recent years. And I have two questions, if I may.
Sure.
The first one is about the illegal evidence obtained by private identities. Like I know, like, I don't know if my understanding is correct, but I know that according to the Fourth Amendment of USA, like if an evidence obtained by an individuals, not by the police, it will not under the Fourth Amendment protection and will not be excluded. And the only remedy or the main remedy will be a civil compensation. But what if, just suppose I'm the person, I really want to put someone in prison. I would rather pay for the civil compensation and I take the evidence through some illegal means and I want to put you in jail. Do you think, like, I don't know your comments, because in Macau, we have two cases recently, and not very recently, in these 2 years. One is a person take a video of someone, his neighbor touching a cat, and the neighbor take the video and then put the video on the internet. This is a crime called illegally intervene of privacy life. And then the person touching the animal was prosecuted because of touching the animal. And the evidence was excluded in the court because according to Macau law, any evidence obtained by illegally intervening the other's privacy life, it has to be excluded.
Right.
So this person touching the cat was acquitted. And the other case happened in a taxi. And a passenger and the taxi driver, they fight because of some dispute about the route the taxi driver is taking. And then because they fight, and then the passenger took out his cell phone and take a video because the driver kept fighting him, beating at him. And then the video sent to the court. Still, it's the same issue because the video is taken without the consent of the taxi driver, even though it's like their communication, because it's different with the first one, because this is like taken by one party of the communication, but still it's an intervening privacy life. So I just want to get some of your comments on this difference.
Sure. So in our system, there are two different ways or two different reasons evidence can be excluded at trial. I mean, I'm very much generalizing here, but one is because the obtaining of the evidence violated the Constitution. That's a constitutional question. and the other is because it violates the law. That's a different question.
Yeah, like SCA, right?
The Constitution, our Constitution, like you refer to the Fourth Amendment, it deals only with the relationship between state actors, people who work for the state,
Yes.
and the citizenry. So the Fourth Amendment, which says people shall be secure in their person's houses, papers, and effects against unreasonable searches and seizures, only affects the government.
Yeah.
Now, again, a big difference between your governmental organization and ours is the central problem we were trying to solve was to limit the central government. Your political problem is how to extend the power of the central government. It's the exact opposite.
Yeah.
So all of our Bill of Rights, like the Fourth Amendment, the Fifth Amendment, these are all part of a larger scheme to limit the power of the central government.
Yeah.
So those kinds of rights exist to protect the people against state, we call it state actors. There has to be state action.
Sure.
So the police, if they engage in unreasonable search and seizure, or any governmental official who engages in an unreasonable search and seizure, that violates the Constitution. And then you get, as you point out, the exclusionary rule. Now, that means the examples you gave are not covered by the Fourth Amendment because those are not state actors. Those are not people who work for the state, right?
Yeah.
There, each of our state, now I'm using the term state in a different way, each of our states, like New York, Illinois, Michigan, Iowa, each of those governmental entities can decide for themselves through their own law whether to go beyond the Fourth Amendment.
Yeah.
And in Illinois, for example, it is illegal actually to videotape a person without that person's consent.
Yeah.
Just like apparently the law of Macau.
Yeah.
And in Illinois, the Congress, the legislature, included an exclusionary rule. So under Illinois law, not the Constitution, but under Illinois law, you can't videotape somebody, and if you do, actually, not only can't you use the evidence, but it's a crime. It's not taken very seriously. Nobody's ever prosecuted for it, but it's theoretically a crime. So you have these two different sources.
Yes.
That you have to keep straight in the United States. The Constitution, but that applies to everybody, everywhere in the country. Doesn't vary from state to state, because it's a federal, national issue. But then within the state, they can all do what they want to do. They can't lower the standards of the Fourth Amendment, but they can raise them, and they can apply privacy laws to individuals. And so we end up in the same situation that you described. Some states would not allow that kind of videotaping. Other states would. So it just varies based on where you live, because the states, remember, in our system, they are sovereign.
Yes.
The name of our country is the United States, the United States of America. All right. So, no, you raise a really interesting issue, and people disagree about this. We've even in those states that say you can't videotape, the police have said, well, that means you can't videotape us. You see a lot of these.
Yeah, it happens in Macau too. Yeah.
Yeah, right. This is a new issue in the United States, but what's starting to appear to be the solution is a citizen, a person legally in the United States, has the right to videotape his interaction with the police as part of their own constitutional rights to privacy and so on and so forth. So it's a really interesting development. That even if a state law says you can't videotape without consent, if you fear that the police are going to behave badly, you have a right to do that, to secure the evidence to show what happened. So lots of interesting things going on here.
Yeah, sure. It's really arguable. If it's if the action of videotape already consists a crime, it's much easier to decide.
Right.
But some actions, as you described, it's not that bad, and even out of the public supervision, according to the public powers, it's even more difficult.
Right.
May I raise? But anyway, thank you so much for your explanation. And I know, like, we are not alone. We are all struggling with this issue.
Right.
May I read? Yeah, I have.
Do you have a second question?
Yeah. Another issue is about the online litigation, because nowadays a lot of laws, criminal trials, even fact finding, moved online. But I noticed, like, there are some countries, they don't allow this. Like fact finding will be like, just as you described at the first lecture of this project, like the evidence is very complexity.
Right.
Yeah. So do you think there shall be some limit on the online trial, especially for the fact finding?
Yeah. So actually, China is leading the way in this direction, as you probably know. My student, I don't know if he's on this lecture. Henry, are you on? Wang Chuao, are you with us tonight? In any event, he's we call him Henry. He has written on this topic and actually informed people in the United States about what's going on in China. It's really interesting.
Yes.
I think that trend is going to continue. The problem is what you identified. The problem is how that relates to complexity.
Yep.
You can do online trials with simple problems.
Yeah.
And it becomes more actually like an arbitration than a trial.
Yeah.
But you don't always know in advance if something's going to be simple or complicated. All right. That's going to be the problem.
Yeah.
So like a house closing, when you buy a house, you have a closing where you sign the final papers and pay the money and this and that.
Yeah.
Usually that's simple, but not always.
Yeah.
So it's going to be a problem if you have a whole category of cases that you say, well, we can have these trials online. Well, some of them are not going to work online. So I think that's going to be problem, sorting out what can be done in a, we say mechanistic. You know English very well. Not everybody may know mechanistic means the mechanical way.
Yeah.
You know, you just follow the steps and things will work out fine. If you can identify cases like that, then those can be done online. And the advantage of it is saving money. I mean, just saving resources and getting things resolved efficiently. So yeah, I think everyone will continue to experiment with this. But just so you all know, right now the world is watching China to see how it works in your country.
Yeah, and there may also cause another issue of jurisdiction, because some online trials, someone may be outside of China. And also I was thinking, like, there may be some similarity with the default trial, because we don't allow all the default trial, because some of them we cannot guarantee the confrontation rights of the accused, or all kinds of guarantee of rights. So I just want to know, like, if you have some reference, because today you recommend so many useful reference to us, and I was actually very interested in this topic ever since last year, but I didn't see too much literature in this area.
Well, again, my student, Wang Chuao, Z-H-U-A, how's he spell his first name? Z-H-U-A-U, I think, Wang, has written on this. Do you know who I'm talking about? We call him Henry. Send me an email and I will send you his.
Okay.
Oh, there he is. Yeah, Wang Chuao, right there in the chat. He has written on this in English in the United States, and he would be the one to talk to and would know the most about it.
Okay, thank you so much.
You're welcome. Nice to see you. Kaibo Wei, what's up?
Okay. Professor Allen, nice to meet you. My name is. I would like to consult you for 2 questions. In regard to criminal procedure, what are the differences between the proving programs in online litigation and the one in ordinary litigation? And what problems should the online litigation proving programs pay attention to? Thank you.
What was the second question? Well, the first one was the problems of online litigation. What was the second question?
The second question, what problems should the online litigation proving programs pay attention to? Yeah, so the problem here is we don't have that in the United States. We don't have online litigation. I mean, it doesn't exist. So I can't answer your question, right? Because we don't have it. You can see from the American point of view, the kinds of problems this is going to generate, that you can see. Because we have again, an adversarial system, and we have these rights. And even in civil cases, you sort of have a right to confront your witnesses. It's not a constitutional right, but it's part of our traditions. You have a right to cross-examine people who are giving testimony. You have a right to confront the evidence against you. And in criminal cases, as we've talked about, that's a constitutional right. I mean, it can't be eliminated. It's not easy to see how evidence can be tested in the same way with online trials. Because one of the major advantages of online litigation is you don't have lawyers, right? I mean, yes,
you don't have lawyers. Well, without lawyers, you can't do what our culture says you should have a right to do. So that's going to be a problem for us. I mean, a serious problem actually, and I don't know how it works out. That's why I said in passing a second ago, in a way, I think what will happen is online litigation will look like arbitration. You know what arbitration is, where people get together and sort of work out a solution? I think that's what will evolve here in the United States. And I also think that people will have a right to opt out, to say, no, I don't want to do that. That I want a regular trial with lawyers and a judge and so on. So I'm just predicting how this is going to evolve. But yeah, that's my response. Number one, we don't have it. Number two, if we do have it, we're going to have these problems of how you test evidence, whether it's called confrontation or whatever. And I don't think many states will not allow that to happen. I don't think we're going to require that people go on to online litigation without lawyers and without the ability to examine and cross-examination. On the other hand, if you can solve your disputes that way, it's in everybody's best interests. So people will be able to choose, I think, to engage in that process, but I don't think they're going to be forced to engage in it.
Okay, thank you.
Yeah, it's very interesting. Okay, any other questions? I don't see any hands. Benson, I see you are now, you're back.
Yeah, interesting. I have 2 questions for you. First one is, can we say, in general, we can regard any new evidence, for example, electronic evidence, digital, AI, big data as scientific evidence? Then that's if so, the judges can verify or check, focus on their relevancy and reliability.
Right.
This is a first question. Yeah.
and I think the answer to that is going to be yes.
Yeah.
That's going to be the approach that the American system takes. Now, that doesn't mean every time a technique or digital evidence is produced or machine learning is used, it doesn't mean every single time you're going to have very complicated Daubert hearings, the reliability and validity hearings. What will happen is you'll have some of those kinds of hearings and some of that kind of testing in early cases, and then principles will be established. And the best example of this, Benson, is DNA. When DNA first started to be used, we had these very complicated hearings where the judges had to decide whether it was accurate and reliable. But then eventually, we all became convinced that if DNA testing is done properly, it's reliable, right? It's relevant and reliable. And so eventually DNA came to be accepted, and now it's unusual to have any serious litigation over it. The litigation in DNA is now not over the science, but over whether people did it right. Like the O.J. Simpson case, as I mentioned, the claim there was the police planted his evidence, his blood, that it wasn't found at the scene, right? That has nothing to do with DNA. That has to do with fraud. Or in another example of DNA, there can be contamination at the lab. Those kinds of things are still litigated, but the underlying science and whether DNA testing is accurate is now just accepted. I think that's going to happen. You're going to see these new techniques, these new devices, these new things being litigated, and then eventually we'll reach a consensus. The courts and the legal system will reach a consensus, and that'll be it, unless somebody comes up with some new ideas. But we are going to go through that process of struggling with all of these techniques, all of them. I mean, we're just not going to accept. Our system isn't going to accept an engineer that says, yes, I have this black box and it produces accurate outcomes.
Okay. Yes, thank you. Another question is for the evidence law research. Could you see Wigmore Wigmore method of chart? Can we use can we use the Wigmore method of chart to develop some computer procedure of model of evidential reasoning?
Yeah, so go ahead, sorry.
Because if so, if it is possible, we can promote the research on the fact finding,
I think
evidential reasoning.
I think that's a really interesting question. And what I would say, first of all, is I would encourage you to investigate that. The very question you asked, can we use charts? He's talking about the Wigmore charts in the book called The Nature of Juridical Proof, Nature of Judicial Science, that has two different names. Was a very interesting, he created Wigmore. I'm a Wigmore professor, as my predecessor here at Northwestern. He created this very interesting way to think about evidence and chart out all the inferential relationships. And Benson is saying, can we think about scientific evidence or machine evidence or digital evidence in that fashion, right? That's your question. I think that question is really interesting and should be investigated. In other words, you and your colleagues should investigate that yourselves. I don't know the answer to that question. It seems to me, sitting here today, that you may very well be able to come up with a blueprint, like a chart, right, of how to test digital evidence as a general matter. Here are the things that you need to think about, and here are how they relate. And that would be a really valuable contribution, Benson. Whether you can do that or not, that is an interesting research project for you. I would encourage you to try. And you would need to have a team of both legal epistemologists, legal scholars, but also software developers and computer engineers. I mean, that's how I would think about this. And I think it's really interesting, and you should try. I don't think you're going to come up with anything that looks like a Wigmore chart of an actual trial, because those are all going to be different based on what the technique is or what the problem is that you're investigating, which is the problem with Wigmore charts, right? The problem with Wigmore charts is one case doesn't apply to the next case because all the facts are different, which is why people don't use the Wigmore charts. But that might be different from, can we come up with ways to think about digital, artificial intelligence, mechanical learning evidence? And so I would just say it's a great idea. Let me know how it goes.
I mean, I'm not interested in the the market of the AI market. I just I think if we can use the Wigmore method of chart in the law school, you know.
Yeah, absolutely.
We can educate the students to exercise the evidential reason.
Right. No,
yeah.
That's the real advantage of the Wigmore charts. The real advantage of them is educational.
Yeah.
It helps people think about, well, like I said in my very first lecture, how you think. It helps you think about how you think, and to formalize it and organize it. It's not very useful in the real world. It's just too complicated, but it's very useful pedagogically with respect to education. But I also think it's useful in the way I just discussed. It would be very interesting to see if you could come up with a general approach to this kind of expert testimony, to test this kind of expert testimony. So yes, I think you're right about education, but I also think there's an interesting project there.
Yeah, okay, thank you.
Yeah, Hongwan Zhou, I think you're next.
Nice to see you again.
Nice to see
hello,
you.
Professor Allen. My question is that in AI testimony review, it's hard for judge use the doubt rule to examine the reliability of AI testimony. The key reason is that the AI testimony is lacking of experimentation and transparency. But do you agree maybe in the futures, just like my supervisor Benson said, use the Wigmore chart and the AI systems to discover that legal reasoning part in that AI testimony? Maybe the doubt rule and the Wigmore chart and AI systems can help judges to understand the AI testimony better, to examine the reliability of AI testimony better in the future. Do you agree?
Yeah, no, that's what Benson and I just talked about. Yes, I do agree. There are many different uses to any particular tool, right? Any tool that you have can usually be used in lots of different ways. I focused in my talk on the use at trial. And the reason I did is that is a big problem. But another use of these tools, like Benson just said and you just said, is educational. And another use, by the way, is investigatory, to help in investigations. So these are different uses: proof of trial, educating students, investigating a problem. Those are all different uses. And when you get away from trial, then you get away from this problem of rights, right? Of violating people's rights or making mistakes and convictions. And then it becomes a different issue. And I think the two of you are exactly right. This could be very valuable in training students. The Wigmore charts, as I said before, are really interesting to show, to expose the way the inferential process can work. And by the way, note I say can work, not must work or does work. It shows a way it can work. It's possible to think of things in this particular way. I would say the same things about these AI systems. And as I was saying to Benson, if you can come up with a chart method of thinking in general about artificial intelligence and machine evidence, that would be a real valuable contribution. So yes, but the point I'm making here is to focus on the fact that a tool, any tool, can be used in lots of different ways. And the different ways in which you use it will determine whether it works well, it doesn't work well, whether you want to use it or not use it. And education, investigation, and trial are really three separate ways that these things we're talking about today can be used. So yeah, good question.
Thank you.
Chen-Xi Wang?
Hello, Professor. Can you hear me?
I can hear you.
Okay, thank you. I have two questions. The first one may sound silly. This is if we get some evidence from big data system, can this evidence be defined as a kind of machine evidence? If not, what's the difference between the two evidence? Is the first question. And the second one is how to protect the privacy of the defendants when we use some technology to get evidence. For example, we use thermal imager to detect the temperature of a room, and we want to get some evidence of whether the defendant is growing marijuana. As we know, a person's house is protected by the First Amendment, but how can we balance the detection power and the protection of privacy? That's all. Thank you.
Right. So, so the way we use the terms, which may not be how you use the terms, big data and machine learning are related to each other. When we talk about machine learning, normally what we're talking about is a huge number of inputs into a computer program, and then the computer program makes decisions about those inputs. So big data just means a lot of data that is then processed by a machine, which is engaging in machine learning. So that's how we use the term. They're related to each other, but machine learning and machine evidence can be of other kinds. The examples we talked about today were now DNA analysis is being done just by putting a drop of blood into one of these complex machines, and it does all the analysis for you. That's related to big data, but really isn't big data. It's really just chemical analysis that's done quickly by these machines. Other examples, though, like fingerprint identification, which is also now being computerized, is big data. You feed a bunch of fingerprints into a program and say these are matches, these aren't matches, and then the program starts to figure out how to match fingerprints. So there you have a lot of data points, big data, being processed by a machine. So I hope that helps. I mean, these are related to each other, but they're not exactly the same. But I also don't think it matters. And just so long as you know how you're using your terms, that's what matters, right?
Okay.
There's no right or wrong here. It's just how you use your terms. The second problem, right, I would say you're asking about the right to privacy, basically. It's a huge problem. In fact, I teach a seminar called The Surveillance State that looks at all the ways in which the government collects information and then the limits the legal limits we impose on that process. And it's, I don't know about China, but in the United States, these problems are everywhere. You cannot walk down a street in an American city without being videotaped by 10, 20, or 100 different video machines. Not all, but a lot of houses now have video machines as a security measure. Some cities are now installing street lights, street lights light up the streets at night with video machines that broadcast back the video of the street to the police headquarters. So it's like the entire city is under video surveillance. Everywhere you go, you leave an electronic trail. Where you go with your cell phone, it's pinging off of cell phone towers, which is a map, gives a map of where you've been. When you use a credit card, that identifies where you are, what you bought. Every one of us is a walking cloud of electronic data. And that electronic data is available to third parties, other people, right? The vendors of your phone, of the store you went to. If you use a key card to get into your university buildings, guess what? There's a record of that. And this is changing the nature of society. It used to be that you could get privacy in a big city because you were anonymous. Nobody knew who you were and you could keep to yourself. It's impossible now. If you go to the big city, you're exposed. Think of two other things. License plate readers. I don't know if you have license plate readers in China, but we now have these video cameras that look at the license plates on your car. Guess what? That identifies who you are, where you are, and so on. And now, of course, the most recent innovation is facial recognition, where through big data, the artificial intelligence is improving, where just by a video of my face, they can figure out who I am. Because there are pictures of me on the internet, and you take my face, you identify my face with other, and off you go. So you're absolutely right. This is a huge change. And we are struggling in the United States with how to regulate it. The problem we have is if you think of constitutional regulation, then you're back to a problem we already discussed tonight, which is that limits the state. It doesn't limit private actors. Most of the data that I just referred to, not all of it, but most of it is collected by private actors, by non-state people. With respect to things like facial recognition and license plate reading, we have not seen that as a violation of privacy, because when you're out in the open, you're not trying to keep that secret. And so if the government sees it, they see it. It's no different from anything else. But it seems to us like it changes when you can't avoid it, when you can't regulate it, when you can't control it. And this is what we're now struggling with in the United States. So I don't have any solutions to this, but I could do another talk on, if you want me to, on really interesting constitutional cases that have come down recently that I'll just use the same term, struggling with this problem, how to deal with this problem of massive amounts of information out there, much of it in the hands of the third party, not a government, but the government wants it. So then instead of going to you and searching you, they go to the third party and say, can we have this data? And then they give it to them. And now is there any protections for me, the private citizen? We are just struggling with that question right now.
Okay, thank you.
Thank you. One last question. Nico, one last question, and then you should.
Hey,
all
hello,
get
Professor. Yeah, I have
turn on your video, Nico.
Oh, sorry, my camera doesn't function.
Okay.
Please forgive me about that. Yeah. I have a question about a thought experiment. Imagine this scenario: a human expert and an expert system. The two kinds of subjects give their own opinion, which are conflicted with each other. Yeah, so this may be not real, but what if this happened in the real court? How can we deal with this situation? I want to hear your voice. Thank you.
Yeah, no, it's a good question. It's an interesting question, and you would do it the way we were talking about tonight. You have to be able to probe the evidence, right? What we mean by the right to confront the witnesses against you, to cross-examine the witnesses, is you have a right to probe and try to show the unreliability of the witness. If you are the person presenting the witness, you have a right to show that they are reliable, to show that they saw what they said they saw and their memory is functioning. And the other side, the opponent, gets to probe those issues to show that it's not a reliable witness. And the best you can do is give access to that kind of technique to the parties. Now, the problem, which is the point of this entire discussion tonight, the problem is that it's just not obvious what that means with respect to machine evidence. So now you have a machine system, an artificial intelligence system that says X, and the witness says not X. You can probe the witness, but how do you probe the machine? And that's exactly what we spent an hour tonight talking about. There are various ways you can do it. You can, again, try to get access to the underlying code. You can try to do validation studies. You can have a second machine do the same test and see if you come out the same way. Now, but look what we're talking about. We're talking about creating the analogy, the cross-examination. That's what we're talking about. And that's what we have to do. We have to come up with the ways that allow us to be confident that at least in many instances, we can guarantee or have reasons to believe the machine is telling the truth. That's the way to think about it. I can't say more than that, because how you would do that in any particular case would depend on what the kind of evidence is, right? Whether it's a DNA test or a fingerprint test or a facial recognition test. It's all going to depend on the particulars. But just like a cross-examination of a witness depends on the particulars of that witness. So in this sense, they're highly analogous. But how you're going to do it, we are going to have to come up with ways to figure that out. Okay, Benson, I think, are we done?
Thank you so much.
Yes. Yes.
It's late. You should all go ahead.
Yes, right.
If I were in China, I would buy you all a drink, a glass of wine or a beer or a scotch. You are staying up late.
If there's a lecture in China, we can finish it and have a dinner.
Exactly. We would have a dinner. But you are all very brave to stay up late on a Saturday night to listen to a talk about machine evidence and artificial intelligence. So it's been fun these last 3 days. I hope you found these lectures interesting.
Yeah, very interesting. Yeah.
All right.
Okay. Thank you.
Thank you, sir.
Thank you, Professor Allen.
Thank you.
Thank you, Professor.
Thank you.
Thank you for listening. Goodbye, everybody.
Goodbye.
Thank you, Professor.
Goodbye.
Goodbye, everybody.
Professor.
Thank you. Bye-bye.